Hello friends, welcome back to the series of lecture. This is the 56th lecture of this series of Indian Evidence Act. So in the previous lecture we had seen up to section 143. Now let's start section 144. And in this, the first part we have already discussed. Read it. Any witness may be asked. Any witness may be asked while is under examination whether any contract, grant or other disposition of property as to which he is giving evidence was not contained in a document, and if he says that it was, or if he is about to make any statement as to the contents of any document which, in the opinion of the court, ought to be produced, the adverse party may object to such evidence being given until such document is produced, or until facts have been proved which entitle the party who called the witness to give secondary evidence of it. So first part we have discussed. The second part, that is oral accounts wala part, that is what is remaining to be discussed. Now read it again. Any witness may be asked while is under examination. अब यहाँ से इधर शिफ्ट हुआ, आप और से आगे बढ़ो. If he is about to make any statement, if he means क्या, witness. If the witness is about to make any statement as to the contents of any document. अब statements as to the contents of the document, where will he give? किस provision में देगा? 63 clause 5. 63 clause 5. If he is about to make any statement as to the contents of any document which in the opinion of the court ought to be produced, the adverse party may object to such evidence being given until such document is produced or until facts have been proved which entitle the party who called the witness to give secondary evidence of it. Until the facts have been proved which entitle the party who called the witness to give secondary evidence of it. तो मतलब ये जो oral contents का जो statement है उसके context में you read it again. Or if he is about to make any statement as to the contents of any document. यहाँ तक पढ़ लिया. Then उसके बाद यहाँ से पढ़ो until facts have been proved. Until the facts have been proved which entitle the party who called the witness to give secondary evidence of it. So there are two dimensions of it. One is, if you remember section 91, that if you are giving oral evidence of any documents, and you are asked to as to whether the transaction was documented or not, and if you say yes, then in 91 mein objection can be raised. And the other fact they are saying, they are not using the oral account, but that is what it is implied here. If an oral account is given as to the contents of the document, then obviously the opposite party can always raise an objection regarding the secondary evidence. अब मान लो आप 63 क्लॉज 5 में oral accounts दे रहे हो contents of document का. अब obviously secondary evidence जब तक allow नहीं होगा, you cannot do that. Until the secondary evidence is allowed, you cannot give the evidence. I hope you appreciate that. ये 63 clause 5 में you are giving the oral accounts of the document. Obviously the opposite party can raise an objection on that. It shall not be allowed until secondary evidence is permissible if fact is proved. तो ये जब तक section 65 prove नहीं होगा, oral accounts will not be given. अब ये चीज़ मैंने उस समय इसलिए डिस्कस नहीं की थी क्योंकि उस समय 63 clause 5 डिस्कस नहीं कर सकता था. Now we are discussing. Write a sentence upon it. Alright. Whenever a witness gives oral accounts of the contents of a document under section 63 clause 5, the opposite party can raise an objection that the oral accounts will not be allowed unless the party concerned proves that he is entitled to give secondary evidence. That is, he has to fulfill the conditions of section 65. So main section is very simple, that if you are giving oral evidence of the contents या फिर of an transaction and you are asked that whether it is recorded or not, and the witness says that yes, it was recorded, then in section 91 the objection will be raised. Then the opposite party says that the oral account will not be given unless the contents of section 65 is proved. Oral accounts will not be given. The evidence will not be allowed. Oral account will not be allowed unless the contents of section 65 will be proved. Now see the explanation. A witness may give oral evidence of statements. A witness may give oral evidence of statements made by other persons about the contents of documents if such statements are in themselves relevant facts. अब इसको समझिएगा, एक्सप्लेनेशन इज इम्पोर्टेंट। अब देखो इसमें एक तरफ तो ओरल एविडेंस बार कर रहे हैं, ओरल अकाउंट एविडेंस बार कर रहे हैं, oral accounts या oral evidence, it is barred. In 91, if it is documented, then prove the document. And if you are giving oral accounts, then you please prove that secondary evidence is allowed. But at the same time, explanation is permitting that a witness may give oral evidence or statement made by other persons. Now suppose there is a document and A makes a statement regarding the contents of this document in the presence of B. B is present. A makes a statement regarding the contents of this document. अब A ने इस डॉक्यूमेंट्स के कंटेंट्स के लिए स्टेटमेंट दिया. A made a statement regarding the contents of this document in the presence of B. If you read the explanation, a witness. Who is the witness? B is the witness in this example. A witness may give oral evidence of statements made by the other persons about the contents of documents if such statements are in themselves relevant facts. If such statements are in themselves relevant facts. Now A regarding the contents of this documents had made a statement. Now in this statement is a relevant fact under some section. In this statement there is a relevant fact under some section. Then B can give the evidence of what? He is not giving the evidence of the contents of the document. He is giving the evidence of what A has stated regarding the contents of the document. He is giving evidence what A has stated regarding the contents of the document. A ने किसी documents के contents के बारे में कुछ कहा and B heard that. Of the statement of A regarding the content is in itself a relevant fact. Is in itself a relevant fact under some section as motive or admission, whatever. Now B can appear in the court and give evidence that A had made such and such a statement regarding the contents of that document. That A had made such and such a statement regarding the contents of the document. अब इसमें who is the witness? B is the witness. अब B may give oral evidence of statements made by A, other person A, about the contents of the document if such a statement is in itself a relevant fact. So regarding this document, A makes some statement. That statement itself in a suit or proceeding is a relevant fact. The statement in that suit is itself a relevant fact. B heard making that statement. B can appear into the court to give evidence as to what A says regarding the contents of the document. Now mind you that B is not appearing here to give the evidence of the contents of the document. तब तो it is disallowed. लेकिन he is giving the evidence of the statement made by A regarding the contents. Now see the illustration. The question is whether A assaulted B. The question is whether A assaulted B. Now C is the witness. अब क्वेश्चन इज दैट कि A ने B पर assault किया था कि नहीं, अटैक किया था कि नहीं. And C gives the evidence. C deposes that he heard A say to D. That he heard A say to D the statement of A. B wrote a letter accusing me of theft and I will be revenged on him. अब B ने कभी कोई एक लेटर लिखा था A को जिसमें उसने कहा था कि तुमने चोरी की है. अब A B को कहता है, D को कहता है, A D को कहता है कि B ने मुझको एक लेटर लिखा था जिसमें उसने कहा था कि तुमने चोरी की है, तो मैं तो बदला लेकर रहूँगा. अब टेल मी दिस स्टेटमेंट ऑफ A, is it relevant somewhere? It is relevant as an admission of motive. He is admitting his motive when he says the contents of the letter, then he also admits motive. What motive? That I will take revenge because he has written such and such letter to me. So that statement is relevant as an admission of motive, and therefore he can give the evidence to prove what A had says regarding the contents of the letter. So read it again. The question is whether A assaulted B. एक क्रिमिनल प्रोसीडिंग्स है और उसमें क्वेश्चन है whether A assaulted B. अब C deposes that he heard A say to D. अब A had made a statement. A had made a statement to D and C was present there and C heard it. Now the statement was regarding a letter. Now this B had written the letter to A, and in that letter B had written that you have committed a theft. Now A says that B had written a letter to me. This letter, B had written this letter to me, and in which he alleged that I have committed theft, and therefore I will take revenge from B. So this statement is talking about the contents of the letter, plus it is also talking about the motive. It is also talking about the motive. Of C can give evidence of what A has stated, because that is the statement is relevant where section 8 to be read along with section 21. Section 8 to be read along with section 21, because that is an admission of motive. So section 8 to be read along with 21, and therefore it is to be allowed to be proved. So write down upon this illustration. Here C is not giving the evidence of the contents of the letter. As such, here C is not giving the evidence of the contents of the letter as such. Rather, his evidence is as to what did A say to D regarding such contents. The statement of A in itself in reference to the contents of the letter is relevant under section 21 read with section 8 as an admission of the motive, and therefore C will be allowed to give the evidence of such statement. अब देखो, अगर डायरेक्टली अगर आप उस डॉक्यूमेंट के कंटेंट्स का एविडेंस दोगे तब तो या तो आप प्रूव करो यदि सेकेंडरी एविडेंस इज अलाउड एंड आई हैव रेड द डॉक्यूमेंट, तो 63 क्लॉज 5 में आई विल गिव द ओवरऑल अकाउंट्स. और या फिर आप ये प्रूव करो, या तो आप ये प्रूव करो कि सेकेंडरी एविडेंस इज अलाउड एंड देयरफॉर आई एम गिविंग द ओरल अकाउंट्स, और या फिर डॉक्यूमेंटेड नहीं है इस वजह से ओरल दे रहे हैं एविडेंस. 91 के लिए it was not documented, therefore giving oral evidence. Otherwise you cannot give the evidence of that. But here he is not giving the evidence of the contents of the document. Here he is giving evidence of the fact that as to what did A state about the contents of the document. So the statement of A is relevant under some section, then only he can be allowed to give evidence of that statement. So that's all. Now please switch over to section 145 अब देखो यहाँ से वी आर स्टार्टिंग विद द टॉपिक क्रॉस एग्जामिनेशन। अब क्रॉस एग्जामिनेशन के लिए आपको जो प्रोविज़न मिलेगा 146 से लेकर 153 तक मिलेगा, और उसके अलावा एक सेक्शन 145 है जो कि क्रॉस एग्जामिनेशन की स्टेज में कॉन्ट्राडिक्शन की बात कर रहा है। इट इज़ टॉकिंग अबाउट द कॉन्ट्राडिक्शन ओनली इफ इट इज़ टू क्रॉस एग्जामिनेशन। तो ये इधर से है 146 ऑनवर्ड, लेकिन 145 में इट इज़ टॉकिंग अबाउट कॉन्ट्राडिक्शन। Contradiction on the basis of what? On the basis of previous recorded statement. Contradiction on the basis of a previous recorded statement. Now see 145. A witness may be cross-examined as to the previous statements made by him in writing or reduced into writing. अब ये जो पहला जो पार्ट है that is talking about cross-examination. A witness may be cross-examined as to the previous statements made by him in writing or reduced into writing. या तो उसने खुद लिखा था या फिर उसने बोला था और किसी और ने उसे राइटिंग में रिड्यूस किया था। Suppose today there is a witness A. Witness A is in the court. Now this witness A had earlier also made the statement. Either he himself has written it or it is reduced into writing by someone. But there is a document of the previous statement. Today he states something and earlier he made a document regarding that statement. The first part of this section is saying that if the copy of that is with the opposite party, then the opposite party can cross-examine you on the basis of that document. Cross-examine means what? Means look at that document. Look at the document and from the document it can frame the question and ask you the questions. So that is what is called cross-examination, asking questions on the basis of the previous statements. That is the cross-examination on the basis of the previous recorded statement. That is the first part of section 145. A witness may be cross-examined. Cross-examined means questions can be asked to him. A witness may be cross-examined as to the previous statements made by him in writing or reduced into writing and relevant to matters in question without such writing being shown to him. Without such writing being shown to him or being proved, but if it is intended to contradict him by the writing, his attention must, before the writing can be proved, be called to those parts of it which are to be used for the purpose of contradicting him. So they are talking about two things. In the first part they are talking about the cross-examination, and second part they are talking about contradiction. And if they intend to contradict you, then before proving the document, then you show that part to him and then you contradict him. If you intend to contradict him, then before proving the document, you show that part to him and then you contradict him. और अगर क्रॉस एग्जामिनेशन करना चाहते हो तो मान लो एक कागज है, दिस इज द प्रीवियस डॉक्यूमेंट. Now suppose today the witness is in the court and suppose it is a prosecution witness. Now defense counsel has got this document, which is a such document which the same witness which regarding the same matter has recorded earlier, has written earlier or has dictated to someone earlier. Now this document is there with the defense counsel. Now this defense counsel will not show this document to you. He will simply read it on his own and frame any question and put that question to the witness. So that is the cross-examination on the basis of the previous recorded statement. But suppose today that witness has said something into the court, and here in this previous statement something just opposite was written, then what will the party do? Then instead of cross-examining him, it may simply highlight that sentence, highlighter से mark करके highlight that sentence and show it to him, that did you state this earlier? If he says that yes I state this, means what? Earlier he stated something else and in the court he is stating something else, so he is contradicted. If he says that I did not say this, then the party will go on to prove that this statement is his statement only. और अगर प्रूव कर दिया कि ये स्टेटमेंट उसी का है, then you are contradicted. Now suppose for example today in the court you are saying that there are 5 people who have committed the murder, but in the previous statement कभी कभी हो सकता है घटना होने के 2 दिन बाद का या उस समय का. अब ये प्रीवियस स्टेटमेंट की कॉपी अपोजिट पार्टी के पास है, तो प्रीवियस स्टेटमेंट लिखवा रखा है, then the opposite party will read it and say that is it not contradictory. Now suppose in written it was there that only one accused was there, I saw only one, and in the court he is saying that I saw 5. So you will highlight that sentence that I saw only one, and you show him that did you record this earlier. If he says yes, then it is contradicted automatically. इसमें कह रहा है 1 और अभी कोर्ट में कह रहा है 5, तो वो खुद अपने आप को कॉन्ट्राडिक्ट कर रहा है. और अगर वो कहता है कि नहीं मैंने नहीं लिखवाया या मैंने नहीं लिखा, तो फिर आपको प्रूव करना पड़ेगा कि ये उसका है, ये स्टेटमेंट उसने लिखा है या लिखवाया. अगर उसकी हैंड राइटिंग में तो हैंड राइटिंग प्रूव करो, और अगर किसी को डिक्टेट करवाया था तो जिसने लिखा था उसको बुलाकर गवाही करवाओ और वो बयान देगा कि ये उसने ही लिखवाया था. सो दैट इज़ व्हाट इज़ कॉल्ड कॉन्ट्राडिक्शन. तो कॉन्ट्राडिक्शन में आपको पहले डॉक्यूमेंट प्रूफ नहीं करना पड़ेगा, पहले आप उससे क्वेश्चन पूछोगे कि पहले तुमने ये लिखवाया था, क्या तुमने पहले ये लिखवाया था या लिखा था. अगर वो कह देता है हाँ, तो कॉन्ट्राडिक्टेड, और कुछ नहीं करना फिर उसमें. और अगर कहता है कि नहीं ये मेरा नहीं है, मैंने नहीं लिखा, नहीं लिखवाया, ये डॉक्यूमेंट मेरा नहीं है, तो आपको प्रूव करना पड़ेगा कि ये डॉक्यूमेंट उसी का है. अब क्रॉस एग्जामिनेशन और कॉन्ट्राडिक्शन में फ़र्क ये है कि क्रॉस एग्जामिनेशन में यू ओनली आस्किंग क्वेश्चंस टू हिम to which he makes the replies, और contradiction में you simply marking that portion of the document, and you are asking him whether he had stated that or not. If he said that I had stated, then he is contradicted, and if he says no I did not stated, then what? If he said that no I have not stated, then you have to prove that document is his. फिर से पढ़ लो. A witness may be cross-examined as to previous statements made by him in writing or reduced into writing. So here they are talking about only asking of questions. So here they are talking about only asking of questions by the opposite party and relevant to matters in question without such writing being shown to him or being proved. तो अगर आप क्वेश्चन क्रॉस एग्जामिनेशन कर रहे हो, आपको ये प्रूव करने की ज़रूरत नहीं है कि ये उसी ने लिखा था एक्सेट्रा. आप सिर्फ उसके बेसिस पे सवाल पूछ सकते हो. इसकी कॉपी उसको नहीं दी जाएगी, कॉपी आपके पास है, एंड यू कैन आस्क हिम क्वेश्चंस. Now what is the purpose of that? To frame a question and asking question. Now he makes a wrong reply and then you contradict him. देखो दो चीज़ें हो सकती हैं, ध्यान से समझिएगा. एक तो ये कि जो उसने प्रीवियस डॉक्यूमेंट दे रखा था, जो उसका प्रीवियस डॉक्यूमेंट ले रखा था उसके बेसिस पर सवाल पूछे, जो उसका प्रीवियस डॉक्यूमेंट आपके पास है. अब इट मे बी पर्सनल डायरी ऑल्सो, सो इट कैन बी एनीथिंग विच द अपोजिट पार्टी हैज गॉट. So on that basis you first ask questions to him. अब if he replied correctly whatever he has written here, उसका same reply is in here in the court, तब तो there is no ambiguity, there is no effect. But suppose while you ask questions he replies and one of the replies goes against what he has written here, then the second party go on to contradict. him. मतलब at the cross examination stage he makes some replies upon the question asked to him which was contradictory which he written here, then in the second part you go on to contradict him, that did you say this, then he says no, then you have to prove that this is his document. If he says yes earlier I said that, then he was contradicted. और या फिर ऐसा हो सकता है कि क्रॉस एग्जामिनेशन से पहले अपने एग्जामिनेशन इन चीफ में उसने कुछ ऐसा स्टेटमेंट किया है विच इज कॉन्ट्राडिक्टरी। एग्जामिनेशन इन चीफ में ही उसने कुछ ऐसा कह दिया है जो कि उसका कॉन्ट्राडिक्टरी है। तो इस सिचुएशन में आपको क्रॉस एग्जामिनेशन करने की ज़रूरत नहीं पड़ेगी। आप फर्स्ट पार्ट में नहीं जाओगे, आप डायरेक्टली सेकंड पार्ट में कहोगे क्या ये तुमने कहा था, दिखाओगे उसको और कहोगे कि क्या ये तुमने कहा था। अगर वो कहता है यस तो कॉन्ट्राडिक्ट हो गया, अदरवाइज यू हैव टू प्रूव दैट ही हैज सेड, मीन्स आप कॉन्ट्राडिक्ट करो उसको। सो मीन्स व्हाट आई एम ट्राइंग टू टेल यू इज देयर कैन बी केसेस वेयर you can go for cross examination first. On that basis some wrong statements extract from him. On that basis you extract some wrong statements from him and then you contradict him on the basis of that document. Then you go to second part. And there can be cases wherein in examination in chief only he has made a statement which is contradictory to this document. So there you don't need to go. You may, but you don't need to go into the cross examination. You rather directly go to the second part of this section and contradict him. मतलब आप इसके फर्स्ट पार्ट में जाओगे तभी सेकंड पार्ट में एंटर करोगे, ऐसा कोई रूल नहीं है। अगर आप चाहो तो डायरेक्टली सेकंड पार्ट में जाकर उसको कॉन्ट्राडिक्ट कर सकते हो। सो इज दैट फाइन? और देखो इस सेक्शन में दो पार्ट्स हैं। एक तो ऊपर वाला पार्ट है जिसमें आप क्रॉस एग्जामिन करने की बात कर रहे हैं, और एक नीचे वाला पार्ट है जिसमें आप कॉन्ट्राडिक्ट करने की बात कर रहे हैं। ऑन द बेसिस ऑफ व्हाट? ऑन द बेसिस ऑफ द प्रीवियस स्टेटमेंट। सो यू कैन गो इनटू क्रॉस एग्जामिनेशन ऑन द बेसिस ऑफ द प्रीवियस स्टेटमेंट, and if he makes some wrong answer, and then you can go into contradicting him. So that is one method. And the other method is that you can directly go into contradiction. If he has made a statement in examination in chief is against what is stated in this document earlier, then in that situation there is no need to go into the first part. You can directly go into the contradiction in the second part. तो बस ये याद रखना कि 145 के लिए ज़रूरी नहीं है कि पहले आप क्रॉस एग्जामिनेशन करोगे तभी कॉन्ट्राडिक्ट करोगे, डायरेक्टली भी कॉन्ट्राडिक्ट किया जा सकता है। जब आप सीआरपीसी का 162 क्लाउज 1 प्रोवाइजो पढ़ोगे, सीआरपीसी का 162 क्लाउज 1 प्रोवाइजो, देन देयर दिस पॉइंट इज इम्पोर्टेंट। अब लिखिएगा इस पे, देयर इज अ केस अपॉन दिस। द केस इज तहसीलदार सिंह वर्सेज स्टेट ऑफ यूपी, Tehsildar Singh versus State of UP 1959 Supreme Court. There was 6 judges bench and the judgment delivered by Subbarao Justice. Right? The witness may be cross-examined by the opposite party. The witness may be cross-examined by the opposite party on the basis of any previous recorded statement. In such cross-examination, the previous document will not be shown to the witness. As such. Rather, simply questions will be asked to the witness on that basis. And if he make some such reply which is contrary to the statement made earlier in the document, then he will be contradicted in the latter part of this section. Now next paragraph. However, if in his examination in chief, if he makes such a statement which is contrary to the recorded statement, then he can be directly contradicted on the basis of the previous statement. The opposite party will mark that portion of previous statement and ask him whether he makes that previous statement. Upon showing the marked portion to him. If the witness admits, then what? If the witness admits then it is a automatic contradiction. And if he does not admit, then the opposite party will prove that the previous recorded statement had been made by that witness only. तो आप डॉक्यूमेंट दिखाओगे और पूछोगे क्या ये सेंटेंस तुमने कहा था। अगर बोलता है हाँ, तो ऑटोमेटिक कॉन्ट्राडिक्ट हो गया कि वहाँ पर कुछ कहा और यहाँ पर कुछ और है। और अगर बोलता है नहीं, तो आप उसके हैंडराइटिंग एक्सपर्ट बुलाकर हैंडराइटिंग एक्सपर्ट से चेक करवाओगे अगर उसने खुद ने लिखा है, इफ ही रोट हिमसेल्फ, या फिर किसी और से लिखवाया था तो उसको बुलाकर एविडेंस करवाओ कि ये डॉक्यूमेंट उसी ने लिखा है। एंड इफ इट प्रूव्ड देन इट इज कॉन्ट्राडिक्टेड, दैट इज कॉल्ड कॉन्ट्राडिक्शन। एक सेंटेंस और लिख लो अब इसमें। Thus it is possible that the witness can be directly contradict in the latter part of section 145 without going into first part of the section 145. Okay, is that fine? अब क्योंकि contradiction कर लिया है तो corroboration भी कर लेते हैं। section 157 in order to corroborate the testimony of a witness, any former statement made by such witness relating to the same fact at or about the time when the fact took place or before any authority legally competent to investigate the fact may be proved. In order to corroborate, अब corroborate करना means what? To support. In order to corroborate the testimony of a witness, मतलब जो वो कोर्ट में अभी कह रहा है उसको आपको सपोर्ट करना है। Earlier also he had made a statement, that can be oral statement, that can be a recorded statement. So earlier also he had made a statement, and today in the court he makes the statement. Today in the court also he makes the statement, and the earlier statement was the same as what he is stating today. Means what? Earlier when he had made the statement, he was fresh in his mind, because they are saying at or about the time when the incident took place. So either he wrote or made the statement himself, or he got dictated it to some authority. जैसे उसने CBI वाले को, CID वाले को या पुलिस को किया था। अब ये याद रखना, अगर पुलिस को अगर बयान दिया है इन द कोर्स ऑफ इन्वेस्टिगेशन तो 162 लग जाएगा, बट दे आर सेइंग he can make a dictation to executive magistrate also, he can make a dictation to a judicial magistrate also, तो वहाँ पर तो 162 नहीं लगेगा। So in those cases either it was a recorded statement. Now suppose today he saw a murder has taken place. Today he saw murder taking place and he saw A killed B in a brutal manner, and he went home and in his personal diary he wrote everything. Or maybe he wrote a letter to a friend, or maybe he wrote something on the Facebook or SMS to a friend, or या फिर the investigation is started, so he makes a statement to a police officer regarding that, or his statement was recorded by a judicial officer. So such previous statements can be used to corroborate, and tomorrow when he stands into the court and says the same thing, and since earlier also he had stated the same thing at the time when the memory was fresh, and therefore that will be used to corroborate. But if the statement was made to the police officer, then obviously that corroborative value was lost, and that will be hit by 162 CRPC, and that can only use for contradiction. तो जब पुलिस ऑफिसर को दिया है तब वो कॉरोब्रेशन में नहीं आएगा, लेकिन अगर किसी और को स्टेटमेंट दिया था तो वो कॉरोब्रेशन में आएगा। अब जैसे जिसको उसने लेटर लिखा था वो लेटर प्रोड्यूस कर दे, जब जिस दिन ये घटना हुई थी उसके रीजनेबल टाइम के अंदर उसने कोई लेटर लिखा था। अब याद करो दूधनाथ पांडे केस, उसमें द सिस्टर शी हैज लॉज्ड द FIR, व्हेन शी स्टैंड्स इनटू द court for the testimony, the FIR will corroborate whatever she is saying, stating in the court. And if she says something opposite, then the same FIR will use to contradict. So FIR का evidence value ये भी होगा that it can be used for corroboration or contradiction. The only point you have to keep in mind is in 157 is that the previous statement need not be a recorded statement, it can be an oral statement also. जबकि 145 में the previous statement has to be recorded. In 145 the previous statement has to be recorded. So एक तो statement यहाँ पर ऐड कर लो आप. In section 145 the previous statement should be recorded only. Now write down upon section 157. For section 157, it is not essential that the previous statement should have been recorded only. It can be recorded or it can be oral. Whatever was in previous statement, comma, if it is the same as the testimony given by witness in the court, then it can be used for corroboration. Corroboration of what? Corroboration of the testimony in the court. Okay. It can be used for the corroboration of the court testimony. It is essential that the previous statement was made by witness at or about such time when the memory of incident was fresh in his mind. मतलब जो स्टेटमेंट प्रीवियस स्टेटमेंट किए थे विटनेस ने वो घटना के आसपास जो भी उसने कहा था तो उस समय उसको याद था, फ्रेश मेमोरी थी उसकी, तो उस कोर्स में उसने कहा था. ओके, so after this we will shift 146 to the 146, that is cross examination. Section 146 that is about cross examination. अब देखो क्रॉस एग्जामिनेशन का आपका क्या पर्पज होगा. मान लो एक विटनेस है, उसको आपको क्रॉस एग्जामिन करना है. विटनेस ने एग्जामिनेशन इन चीफ में जो भी बातें कहनी थी वो कह दी, या फिर एक सिविल मैटर है तो उसमें एफिडेविट लगा चुका है. सो द विटनेस हैज ऑलरेडी स्टेटेड chief examination in chief that he wanted to say whatever he wanted to say he has stated in examination in chief, or the witness had filed an affidavit in the civil matter of his examination in chief. So he had made some statements regarding the facts concerned. तो जिस facts का वो statement देने आया है उसके लिए उसने कुछ statements कर दिए. He has made some statements. Now the opposite party will go for cross-examination. Now in the cross-examination opposite party, what is the purpose of the cross-examination? One purpose is the previous statement recorded था उसके basis पर उसको cross examine करना या contradict करना. और दूसरा purpose है कि उससे इस तरीके के सवाल पूछे जाएं. You will ask some such questions which will shake his credibility. कि देखो पहले इसने कुछ और कहा था, अब कुछ और कह रहा है. To shake his veracity. Veracity मतलब क्या? Truthfulness. So your purpose in cross examination will be to ask him some such questions which affects his credibility, truthfulness, or you can say that impeach his credit. Credit मतलब trustworthiness. So you just want to ask him some such questions which will affect his veracity, means वो जो कह रहा है वो सही नहीं कह रहा. अब मान लो एग्जामिनेशन इन चीफ में he has said that I was standing at a distance of around 50 meters from the place where the incident took place and I could see in the night. अब in the cross examination when he is asked he says that the distance, अब उससे क्वेश्चन पूछा गया what was the distance, he said 50 meters. Then he asked where was the place, then he suggests some place. What was the time, अब रोई रात का समय बताया उसने, night, it was night. अब it was asked whether there was some street light, then he said no. Then the question came that how did you see in the dark. Then he asked that do you wear spectacles, he said yes. मतलब आपकी आंखें कमजोर भी हैं, थोड़ी कमजोर भी हैं, फिर भी आपने इतनी दूर से कैसे देख लिया. So that is where his truthfulness will be affected. मतलब ये विश्वास योग्य नहीं है, क्योंकि कोई भी व्यक्ति 50 मीटर की दूरी से क्लियर अंधेरे में क्लियर नहीं देख पाएगा। कोई भी रीजनेबल पर्सन 50 मीटर की दूरी से अंधेरे में क्लियर नहीं देख पाएगा, इंसिडेंट को क्लियरली नहीं देख पाएगा। Therefore he is not very trustworthy. So that way your purpose is to ask him such questions which affect his veracity, which will affect his credibility. अब जैसे आपने विटनेस से पूछा तुम कौन हो, क्या करते हो, उसने बताया कि मेरा बिजनेस है। फिर क्वेश्चन पूछा किस चीज़ का बिजनेस है, वो नहीं बताऊंगा, उसने आंसर दिया वो नहीं बताऊंगा। मान लो चोरी का सामान लेने का बिजनेस है या फिर ऐसा कोई बिजनेस है, तो मीन्स ये विटनेस ट्रस्टवर्दी नहीं है। तो उस तरीके के सवाल आप पूछोगे उससे और उन सवालों के वो जवाब देगा, उसके बेसिस पर उसकी क्रेडिबिलिटी डिस्टेबलाइज हो सकती है। अब एग्जामिनेशन इन चीफ में तो ही वॉज वेरी परफेक्ट। अब क्रॉस एग्जामिनेशन में द सडन क्वेश्चन विल बी आस्क्ड टू हिम, unexpected questions will be asked to him, and there he makes some natural replies to those questions, continuous reply to those questions, and somewhere he makes the wrong statements. So that can be used to show or to prove that he is untrustworthy. So read 146. When a witness is cross-examined, he may, in addition to the questions herein before referred to, be asked any question which tend. You see, when a witness is cross-examined, he may, in addition to the questions herein before means what? Herein before means what? 145, section 145. When a witness is cross-examined, he may, in addition to the questions herein before referred to, be asked any questions which tend to test his veracity. Veracity मतलब उसने सच बोला है या झूठ बोला है। Test his truthfulness. Then to discover who he is and what is his position in life. What is his position in life? अब मान लो आपने सवाल पूछा विटनेस से, क्या तुम एक्यूज्ड को जानते हो? Then he said yes. अब आपने पूछा कैसे जानते हो? फिर उसने बताया, and it comes out that there is a family rivalry between these two, between the accused and the witness. Then there again the truthfulness of the witness will be affected, because he may be proved to be a interested witness. Interested मतलब biased witness. So to test his veracity, to discover who he is and what is his position in his life, or to shake his credit by injuring his character, although the answer to such questions might tend directly or indirectly to criminate him, or might expose or tend directly or indirectly to expose him to a penalty or forfeiture. So to shake his credit by injuring his character. किसका character? Witness का character. By injuring the witness character. Although the answer to such questions might tend directly or indirectly to criminate him, or might expose or tend directly or indirectly to expose him to a penalty or forfeiture. मान लो कोई क्वेश्चन ऐसा है जो कि विटनेस के क्रेडिट को इंजर तो जरूर करेगा, लेकिन विटनेस को किसी क्रिमिनल चार्ज के लिए एक्सपोज भी करेगा। तो क्या वैसे सवाल पूछ सकते हैं आप? आपने विटनेस के क्रॉस एग्जामिनेशन में ऐसे सवाल पूछे जो विटनेस की क्रेडिट को सेक कर जरूर करेगा, लेकिन बट दैट विल ऑल्सो एक्सपोज द विटनेस टू सम क्रिमिनल चार्ज. So can you ask such questions? Yes. Answer is yes. And does the witness has the protection under 132 proviso? Yes. So 132 will apply in such cases. If the question is such which is self-incriminating, then the protection of the 132 will be available to the witness. So ये आगे next section में लिखा है, 147 पढ़ लो एक बार. If any such question relates to a matter relevant to the suit or proceeding, the provisions of section 132 shall apply thereto. Means if you are asking questions to some relevant facts and the answers to the questions are such which will self-incriminate the witness, then the protection of the 132 will available. Then the protection of 132 is available. फिर से पढ़ लो एक बार. When a witness is cross-examined, he may, in addition to the questions hereinbefore referred to hereinbefore referred to means 145 वाला questions, hereinbefore referred to means 145 वाला questions, be asked any questions which tend to test his veracity. मतलब जो उसने एग्जामिनेशन इन चीफ में कहा है वो सच है कि नहीं, इसको चेक करने के लिए आप सवाल पूछ सकते हो. आप अपनी इंटेलिजेंस से कोई भी सवाल पूछ सकते हो, जरूरी नहीं कि प्रीवियस डॉक्यूमेंट से ही पूछोगे. अपने इंटेलिजेंस से आप कोई भी सवाल पूछ सकते हो जो कि रेलिवेंट फैक्ट से रिलेटेड है. देन टू डिस्कवर हु ही इज एंड व्हाट इज हिज पोजीशन इन लाइफ, और टू शेक हिज क्रेडिट बाय इंजोरिंग हिज कैरेक्टर. जैसे क्या तुम पहले चोरी के लिए कन्विक्ट हुए हो, क्या तुम में पहले लड़ाई हुई है, तो इस तरीके के क्वेश्चन. सो दैट विल इंजोर his character and shake his credibility, thereby shake his credibility. Although the answer to such questions might tend directly or indirectly to criminate him. Although the answer to such questions might tend directly or indirectly to criminate him, or might expose or tend directly or indirectly to expose him to a penalty or forfeiture. तो इस नेचर का क्वेश्चन अगर है, if the question is of this nature, then in that case what 132 will apply, and therefore he cannot be prosecuted only on the basis of those answers if other conditions of 132 are fulfilled. If proviso of 132 you are remembered, then he cannot be prosecuted only on the basis of those answers. So that is what they have written in 147. That is what they have written in 147. If any such questions relates to a matter relevant to the suit or proceedings, the provisions of section 132 shall apply. Means protection of 132 will be available to the witness. Protection of the 132 will be available to the witness. Then read the proviso. Provided that in a prosecution for rape or attempt to commit rape, it shall not be permissible to put questions in the cross-examination of the prosecutrix as to her general immoral character. So that is just a guideline. That is a rape victim. Prosecutrix in rape means what? Rape victim. अब उसका क्योंकि वो witness है, the rape victim is a victim and plus she is a witness also. So she appears in the court and there she give testimony in the examination in chief. अब क्रॉस एग्जामिनेशन में आप उससे सवाल पूछते हो, you can ask any question, but suppose you start asking the question regarding her antecedents, her immoral character, that you are for example that you are a sex worker, are you a sex worker, are you a prostitute, तो इस तरीके के सवाल पूछे आपने, will that be allowed? आंसर इज नो. वैसे भी रेप केसेस में सेक्स वर्कर है या नहीं है उससे कोई फर्क नहीं पड़ता, अगर सेक्स वर्कर है तब भी रेप हो सकता है. देन ऑल्सो द ऑफेंस ऑफ रेप बी प्रूव टू हैव बीन कमिटेड. देन ऑल्सो द ऑफेंस ऑफ रेप प्रूव टू हैव बीन कमिटेड. So therefore such question which injure her character unnecessarily, वैसे सवाल आप उससे नहीं पूछ सकते. Provided that in a prosecution for rape or attempt to commit rape, it shall not be permissible to put questions in the cross-examination of the prosecutrix as to her general immoral character. तो देखो अभी तक जो आपने पढ़ा, that is about asking questions of fact in issue or relevant fact. मतलब जो भी सवाल पार्टी का होगा that is about some fact in issue or relevant fact. अब can a party ask such questions also which are not related to the case, अब उसके लिए आपको 148 onwards पढ़ना पड़ेगा. Read section 148. if any such question relates to a matter not relevant to the suit or proceeding, if any such question relates to a matter not relevant to the suit or proceeding, except insofar as it affects the credit of the witness by injuring his character, the court shall decide whether or not the witness shall be compelled to answer it, and may, if it thinks fit, warn the witness that he is not obliged to answer it. In exercising its discretion, the court shall have regard to the following considerations. You see, now what we are talking about is these questions we are talking about in 148 is not related to the suit as such or proceeding as such. They are not relevant fact. सेक्शन 148 का जो मेन पॉइंट है वो ये है, these questions we are talking about are not relevant fact. They are relevant only to the extent that they affect the credit of the witness. लेकिन वो सूट या प्रोसीडिंग्स का जो रेलिवेंट फैक्ट है उससे रिलेटेड नहीं है. जो सूट या प्रोसीडिंग्स का फैक्ट इन इशू या रेलिवेंट फैक्ट है उससे रिलेटेड नहीं है, ये विटनेस के क्रेडिट से रिलेटेड है. इफ यू रीड इट अगेन, if any such question relates to a matter not relevant to the suit or proceeding, means that question that you are asking is not relevant to the suit or proceeding, except in so far as it affects the credit of the witness by injuring his character. मतलब जो आप सवाल पूछ रहे हो विटनेस से, वो सवाल उस सूट या प्रोसीडिंग में रेलिवेंट नहीं है या रेलिवेंट फैक्ट से रिलेटेड नहीं है, लेकिन विटनेस के क्रेडिट को अफेक्ट करेगा बाय इंजरिंग हिज कैरेक्टर. So it is relevant to the character or credit of the witness. It is relevant to the character or credit of the witness. It is not relevant to the suit or proceeding as such. It is not relevant to the suit or proceeding as such. Except in so far as it affects the credit of witness by injuring his character, the court shall decide whether or not the witness shall be compelled to answer it. Because you see in section 132, witness can be compelled to answer the question. तो अगर आप एक बार 132 निकालो, it is written, a witness shall not be excused from answering any question as to any matter relevant to the matter in issue. It is written relevant to the matter in issue. So that is a very important discussion. मतलब आप किसी relevant fact पर सवाल पूछते हैं, आप किसी relevant fact पर सवाल पूछते हैं. If you ask the questions on some relevant facts, then in that case, the witness is bound to answer in section 132. But here in section 148, the matter is not relevant to the suit or proceeding. You are asking question not to the relevant fact. You are asking questions related to the character to that witness. And therefore the 132 will not apply. So it is the discretion of the court to compel the witness to answer that question or not to compel to answer that question. So write a point upon this. Right? Section 132 applies only upon the questions which pertain to relevant facts or fact in issue in the case. However, if the question relates only to the character of a witness and not to any relevant fact in the case, then section 132 will not apply. Therefore, in such a case, the discretion would lie upon the court to compel or not to compel the witness to answer such questions. Okay? तो अगर उस सूट या प्रोसीडिंग्स के रेलिवेंट फैक्ट या फैक्ट इन इशू पर सवाल है, तब तो witness can be compelled under section 132 to give answer, though he will get the protection of the proviso also. But if the question is not relevant to the suit or proceeding, then it is relevant only to the character of the witness. Now actually it is not relevant. It is related only to the character of the witness to impeach his credit, to injure his credit. Then in that case, the court can compel or the court may not compel. अब मान लो कॉमन सेंस पे सोचो, आपने उस विटनेस के कैरेक्टर को इम्पीच करने के लिए कोई सवाल पूछा इंजर करने के लिए कोई सवाल पूछा, लेकिन वो सवाल डिस्प्रपोर्शनेट है। डिस्प्रपोर्शनेट मतलब जितना उस सूट में उस सवाल का इम्पोर्टेंस है उससे ज़्यादा तो वो बेचारा बदनाम हो जाएगा। बदनाम समझ रहे हैं? मतलब उसके कैरेक्टर से रिलेटेड कोई ऐसी बात पूछ ली, उस विटनेस का टेस्टिमनी उस सूट में या प्रोसीडिंग में इतना ज़्यादा मटेरियल नहीं है और फिर भी आपने उसमें उसके कैरेक्टर से रिलेटेड कोई ऐसा सवाल पूछ लिया जो कि विच इज़ स्कैंडलस अगेंस्ट दैट विटनेस, अब should the court allow that question? Answer is no. But if the question is very important and also the witness is also very important, the fact upon which he came to give the evidence is a very material fact. The fact upon which he came to give the evidence is a very material fact, and the question is very important, and it will go on to establish whether he is trustworthy or not. Then the court shall allow that question. So the question which the court will allow under this section are called proper questions. The question which the court allow in this sections are called proper question, and the questions will the court will not allow are called improper questions. The questions the court will not allow in this section are called improper questions. So the essential guidelines are laid down in the subsequent paragraph. अगर प्रॉपर क्वेश्चंस हैं तो कोर्ट अलाउ करेगा, अगर प्रॉपर क्वेश्चंस हैं तो कोर्ट अलाउ करेगा और विटनेस को कंपेल भी करेगा, और अगर इम्प्रॉपर क्वेश्चंस हैं तो विटनेस को कंपेल नहीं किया जा सकता और क्वेश्चन भी अलाउड नहीं होगा। अगर इम्प्रॉपर क्वेश्चंस हैं तो क्वेश्चन अलाउड नहीं होगा और विटनेस को कंपेल नहीं किया जा सकता। सो इन एक्सरसाइजिंग its discretion, the court shall have regard to the following considerations. First, such questions are proper if they are of such a nature that the truth of the imputation conveyed by them would seriously affect the opinion of the courts as to the credibility of the witness on the matter of which testifies. Such questions are proper if they are of such a nature that the truth of the imputation conveyed by them would seriously affect the opinion of the courts as to the credibility of the witness on the matters to which he testifies. So these will be called proper questions because that will necessarily go on to affect the credibility of the witness. And such questions are improper if the imputation which they convey relates to the matter so remote in time or of such a character that the truth of the imputation would not affect or would affect in a slight degree the opinion of the court as to the credibility of the witness on the matter to which he testifies. So they are saying that if the implication which they convey relates to matters so remote in time or of such a character, which does not affect his present credibility. अब मान लो उस विटनेस ने आज से 20 साल या 30 साल पहले कोई एक ट्रायल किया था, कुछ रॉन्ग किया था, तो किसी क्राइम में इन्वॉल्व था या कोई क्राइम किया था 20 साल या 30 साल पहले, तो जिसके लिए ट्रायल चली थी, तो ये जरूरी थोड़ी कि वो आज भी क्रिमिनल है। He has committed a wrong, but after that he started living a good life. अब यहाँ पर you are raising a question to him that कि आज से 30 साल पहले तुम्हारा क्या चोरी के लिए कन्विक्शन हुआ था। अब उस समय अगर कन्विक्ट हुआ था तो that does not mean कि after 20 years or 15 years this person will still be bad person or doing such kind of crimes. So there the court will not allow such kind of questions and will not compel the witness to answer that question because that is too remote in time and that would slightly affect or not at all affect the credibility of the witness in the present matter. But if he is involved in such a wrong recently, then it will affect his present credibility. So that is why they are saying, if the imputation which they convey relates to matters so remote in time or of such a character that the truth of the imputation would not affect or would affect in a slight degree the opinion of the court as to the credibility of the witness on the matter of which he testifies, would not affect or would affect in a slight degree the opinion of the court as to the credibility of the witness. So means whatever you asking is of such a kind which does not affect his credibility at all or which slightly affect his credibility, then the court will not allow that question. Then third, such questions are improper if there is a great disproportion between the importance of the imputation made against the witness's character and the importance of his evidence. अब ये आपको पहले ही बता दिया मैंने कि अगर आप अब उसको स्कैंडलाइज करना चाह रहे हो, उसके कैरेक्टर से रिलेटेड क्वेश्चन पूछ रहे हो, लेकिन उसका कुछ इस केस से रिलेटेड बहुत ज़्यादा इम्पोर्टेंस नहीं है, वो विटनेस इस केस से बहुत ज़्यादा इम्पोर्टेंट नहीं है, दैट विटनेस इज़ नॉट वेरी वेरी इम्पोर्टेंट और वेरी वेरी मटेरियल इन दिस केस, उसकी बहुत ज़्यादा इम्पोर्टेंस नहीं है इस केस में. ही इज़ रिलेटेड टू रेलिवेंट फैक्ट, but that relevant fact is not a very very material kind of fact or evidence. That witness is related to relevant fact, but that relevant fact is not very very material kind of evidence. So in those cases such disproportionate kind of question will not be allowed to ask. So in those cases such disproportionate question will not be allowed to ask. मतलब विटनेस का जितना इम्पोर्टेंस उस केस में नहीं है, जितना उसका इम्पोर्टेंस उस केस में नहीं है, उससे ज़्यादा तो उसका कैरेक्टर डिफेम हो जाएगा, उससे ज़्यादा तो उसको हानि हो जाएगी, एंड देयरफॉर इट इज़ नॉट अलाउड. सच डिस्प्रोपोर्शनेट क्वेश्चंस आर नॉट अलाउड. देन फोर्थ वन, द कोर्ट में इफ इट सीज फिट ड्रॉ फ्रॉम विटनेसेस refusal to answer the inference that the answer if given would be unfavorable. अब suppose there was a proper question, then the court asked him to answer that question and he did not. अब 132 तो लगेगा नहीं. अब he did not answer the question, then in that case the court can draw inference that the answer would go against him, therefore he is not answering the question. अब ये इन्फ्रेंस तो आप 114 में भी निकाल सकते हो. The court may raise a presumption also. that question may go against the witness, therefore he is not replying or not answering. Okay. You see, अब next what we are doing is, अब 148 में जो सवाल पूछे गए, कोई भी सवाल, are you a dacoit, are you a thief, are you convicted for so and so offense, any kind of question. Now 148 में जो सवाल पूछे गए, उनको पूछने के लिए लॉयर के पास रीजनेबल ग्राउंड होना चाहिए. It is not that you will ask the question in abstract. So he has to have reasonable grounds, and if he does not have the reasonable grounds to ask that question, then the court will not allow that question. और अगर आपने बिना रीजनेबल ग्राउंड का क्वेश्चन पूछा तो आपके ऊपर कोर्ट हाई कोर्ट में लेटर भेज सकता है that this person is asking questions without reasonable ground, और आपका लाइसेंस भी सीज हो सकता है. So that is very strange thing, but in 150 we are talking about it. पहले 149 पढ़ो पहले. So it is saying no such question as is referred to in section 148. No such question as is referred to in section 148 ought to be asked unless the person asking it has reasonable grounds for thinking that the imputation which it conveys is well founded. Means जो इम्प्यूटेशन आप उस क्वेश्चन के थ्रू लगाना चाह रहे हो, उसके पीछे आपके पास कुछ रीजनेबल ग्राउंड, वेल फाउंडेड मीन्स व्हाट, मीन्स देयर शुड बी सम रीजनेबल ग्राउंड्स। आप जो इम्प्यूटेशन उस क्वेश्चन के थ्रू लगाना चाह रहे हो उसके पीछे देयर शुड बी वेल फाउंडेड, there should be some reasonable grounds. For example, you see the illustrations. A barrister is instructed by an attorney or vakil that an important witness is a डकैत। अब उसको किसी ने कहा बैरिस्टर को कि ये जो विटनेस है ये डकैत है, तो मीन्स व्हाट, मीन्स यू हैव द रीजनेबल ग्राउंड, you have told by someone that he is a dacoit, you have told by someone that he is a dacoit, so this is a reasonable ground for asking the witness whether he is a dacoit। अब सोचो कोर्ट में आप पूछोगे किसी से क्या तुम डकैत हो, तो ऐसे क्वेश्चन पर तुरंत अपोजिट पार्टी ऑब्जेक्शन रेज कर देगी that no sir, this question will not be allowed, then this party will say that I have reasonable ground, I have been told by so and so person that he is a dacoit, द ऑब्जेक्शन। तो ऐसे क्वेश्चंस पर तुरंत अपोजिट पार्टी का ऑब्जेक्शन आएगा। सो द मोर यू नो दिस, अब जुडिशियरी के लिए तो इतना बेनिफिशियल नहीं है, सो वी आर लिमिटेड टू बेयर एक्ट्स ओनली, बट जब आप प्रैक्टिस में कर रहे होगे या फिर प्रैक्टिस कर रहे हैं कुछ लोग, तो दीज आर वेरी इंपॉर्टेंट एरियाज इन प्रैक्टिस। सो द मोर यू नो दिस द बेटर ऑब्जेक्शंस यू कैन रेज। जितना ज़्यादा आपको पता होगा कि विच क्वेश्चंस आर नॉट अलाउड, अब the party which asking the question will justify the question. If it is justified, then the court will allow, otherwise it will not allow. ऐसे ही यहाँ पर this question is not allowed because this is a question without any reasonable ground. The party will say this. Then the lawyer will say, no, I will have the reasonable ground. I was told by XYZ जो भी that he is a dacoit. B. A pleader is informed by a person in the court. A pleader is informed by a person in the court that an important witness is a dacoit. The informant, on being questioned by the pleader, gives satisfactory reason. The informant, on being questioned by the pleader, gives satisfactory reasons for this statement. This is a reasonable ground for asking the witness whether he is a dacoit. अब जिसने बताया लॉयर को, उससे लॉयर ने पूछा कि तुम किस बेसिस पे कह रहे हो कि ये डकैत है। अब उसने कुछ ग्राउंड समझाए कि मैं इस वजह से कह रहा हूँ कि ये डकैत है। अब अगर लॉयर उससे सेटिस्फाइड है, देन ही इज हैविंग अ रीजनेबल ग्राउंड। अब सी देखिए इलस्ट्रेशन। अ विटनेस ऑफ हुम नथिंग वॉट एवर इज नोन, अ विटनेस ऑफ हुम नथिंग वॉट एवर इज नोन इज आस्क्ड एट रैंडम वेदर ही इज अ डकैत। अब विटनेस के बारे में आपको कुछ पता नहीं है, विटनेस सामने खड़ा है और वकील साहब ने पूछा क्या तुम चोर हो। विटनेस के बारे में आपको कुछ नहीं पता, देयर आर नो रीजनेबल ग्राउंड्स फॉर द क्वेश्चन, तो उसका कुछ रीजनेबल ग्राउंड तो होना चाहिए। इफ देयर इज नो रीजनेबल ग्राउंड देन दैट क्वेश्चन विल नॉट बी अलाउड। नाउ नेक्स्ट, अ विटनेस ऑफ हुम नथिंग वॉट एवर इज नोन, बीइंग क्वेश्चनड एज टू हिज मोड ऑफ लाइफ एंड मीन्स ऑफ लिविंग gives unsatisfactory answers. This may be a reasonable ground for asking him if he is a dacoit. A witness है वो बहुत अय्यासी से जीता है, he got several houses, several cars, several persons serving him, etc. etc. अब he is asked कि इतने पैसे तुम लाते कहाँ से हो। अब that question he is not able to answer, that he does not answer, he is not able to answer that. So you can always ask him that are you a smuggler, are you a dacoit। तो ये पहले के सवाल जमाने में चलता था, डकैत, स्मगलर। अब के ज़माने में करप्ट पर्सन लिख लो, अगर गवर्नमेंट ऑफिशियल है तो करप्ट पर्सन लिख लो, क्योंकि डकैत तो काफ़ी रेयर होते हैं आजकल। नाउ सेक्शन 150 प्लीज। इफ द कोर्ट इज ऑफ द ओपिनियन दैट एनी सच क्वेश्चन वाज आस्क्ड विदाउट रीजनेबल ग्राउंड्स, it may, if it was asked by any barrister, pleader, vakil or attorney, report the circumstances of the case to the High Court or other authorities to which such barrister, pleader, etc. is the subject in the exercise of his profession. मतलब अगर आपने अनरीजनेबल ग्राउंड्स पर विदाउट रीजनेबल ग्राउंड्स पर क्वेश्चन पूछे तो इस मैटर का रिपोर्ट ऊपर भेजा जा सकता है और वहाँ से ऑर्डर आ सकता है कि इनका लाइसेंस निरस्त करो। वैसे एक बार में ऐसा नहीं होता। अगर बार बार आपकी आदत है, कोई भी विटनेस आता है आप उससे पूछते हो आर यू डकैत, तो कुछ इस काइंड के बिहेवियर के लॉयर्स होते हैं, तो वैसे लॉयर्स के लिए है ये। मीन्स डिस्पाइट द रूल्स यू आर नॉट फॉलोइंग द रूल्स। सो कई प्रोफेशनलिस्ट ऐसे होते हैं जो अगली काइंड ऑफ लैंग्वेज दे आर यूजिंग, टेबल पे हाथ मार मार कर बात करेंगे, वेरी एग्रेसिव, दे आर नॉट रेस्पेक्ट द बेंच ऑल्सो, नॉट मेंटेन द डेकोरम ऑफ द कोर्ट। तो फिर अदरवाइज भी एक्शंस लिए जा सकते हैं। द जज कैन ऑलवेज मेक स्ट्रिक्ट रिमार्क्स फॉर दैट लॉयर इन द जजमेंट itself. So there are very strong remarks the judges pass against the lawyer at times, which should be avoided because the balance of between the bar and bench, जो bar and bench को balance है, that is very important in the interest of justice. So as a lawyer you should avoid, and as a judge also you should avoid. As a lawyer you should avoid to insult the judge, and as a judge you should avoid to insult the or pass the remarks against the lawyer. So that is a very important aspect of the justice. It is necessary for to do the interest of justice. Now after that 151 and 152, if the questions are a scandalous kind of question, if the questions are a scandalous nature, indecent kind of question, or insulting or annoying kind of question, then in respectively 151 and 152 you cannot ask that questions. For example, मान लो रेप का केस चल रहा है. Now you are asking the questions to lady that who has been raped. So obviously there are some personal questions that you have to ask her, but your intent should be good. The intent of the cross-examination party should be good. But if he just want to impeach the credit of the lady by asking her some questions which are related to consensual terminology, etc., then that will not be considered to be indecent and that cannot be stopped. क्योंकि even though that question is of indecent nature question, but it is important, वो जरूरी है, so the court will not stop that kind of question. But if the intent is bad, the formation of the question is bad, because you can ask those questions in more sophisticated decent language, but you are being at times you are being very vulgar using type of language at that time to the lady, then the court can stop the lawyers to asking that kind of questions in that particular form. अब जैसे रेप केसेस में, outraging of the modesty cases में, there are certain questions which the lawyer will ask and he should ask, otherwise justice नहीं हो पाएगा. लेकिन क्वेश्चन का जो कलर है, कलर you understand the nature of the question, it should be more sophisticated and decent as it can be. क्योंकि कई बार क्या होता है कि in the court proceeding judges is there, opposite lawyer is there, family members of the victim was there, some other people may be there. अब लेडीज से आप इस तरीके के सवाल पूछ लेते हो क्रॉस एग्जामिनेशन में जिससे वो हेजिटेट करने लग जाती है टू गिव द आंसर्स. शी मे नॉट बी एबल टू गिव ऑल द आंसर्स. So at that time the judge's roles become very important. It is the duty of the judge to encourage the woman to speak whatever she want to speak. And at times if it is very vigilant of the question and the lawyer said no, it is decent, it is essential, then the judge can always tell him or her that you must answer question in more sophisticated and decent manner. अदरवाइज रेप एक्सेट्रा के केसेस में उस तरह के क्वेश्चंस पूछे जाने चाहिए और पूछे जाते हैं, उसको आप इंडिसेंट मानकर स्टॉप नहीं कर सकते. फॉर्म ऑफ द आस्किंग क्वेश्चन शुड बी दिस. तो वो दे रखा आपका 151 और 152 में. They are saying the court may forward any questions or inquiries which it regards or as indecent or scandalous, although such questions or inquiries may have some bearing on the questions before the court, unless they relate to facts in issue or to the matters necessary to be known in order to determine whether or not the facts in issue existed. Then 152. The court shall forward any question which appears to it to be intended to insult or annoy, or which, though proper in itself, appears to the court needlessly offensive in form. Okay. Now 153. Section 153. When a witness has been asked and has answered any question which is relevant to the inquiry only insofar as it tends to shake his credit by injuring his character. मतलब ये 148 वाले क्वेश्चंस हैं, जो कि ये क्वेश्चंस उस केस में रेलिवेंट नहीं है. द क्वेश्चंस आर नॉट रेलिवेंट टू द केस. इट इज relevant only to the character to the witness, and that question is asked to the witness and witness has answered that question. Then they are saying no evidence shall be given to contradict him, but if he answers falsely he may be afterwards be charged with giving false evidence. So simple सा point है कि अगर एक witness under examination है, if there is a witness under examination in the court, then you ask him questions. You ask him proper questions which fall under 148. You ask him those questions which properly fall under 148. Means they are not related to the relevant fact, etc. They are related only to the character of the witness. Only related to the character of the witness. And now that answer he has given, जो भी आंसर उसने दिया, अब जैसे आप कहते हो आर यू अ डकैत, वो कहता है नो आई एम नॉट ए डकैत, वो कहता है नो आई एम नॉट ए डकैत. अब ये जो पार्टी है वो एक्चुअली प्रूव करना चाहता है ही इज एक्चुअली अ डकैत. सो कैन यू बी अलाउड टू गिव द एविडेंस दैट ही इज अ डकैत? आंसर इज नो. लेकिन इफ ही हैज मेड अ फॉल्स स्टेटमेंट, तो फॉर्जरी के लिए, फॉल्स एविडेंस के लिए उस पर अलग से 193 आईपीसी का मुकदमा चला लो. लेकिन उस केस में अब वो मना कर रहा है कि नो आई एम नॉट ए डकैत, तो इसको डिस्प्रूव करने के लिए आप फर्दर एविडेंस नहीं दे सकते, बिकॉज द रीजन बीइंग इज दैट इज रिलेटेड टू हिज कैरेक्टर. नो, दैट इज नॉट रिलेटेड टू अ रेलिवेंट फैक्ट. अदरवाइज दैट वुड बी अ लॉन्ग चेन. जैसे एक बार आप उससे सवाल पूछो, फिर उसने मना कर दिया, फिर आप उसको प्रूव करो, फिर उसको प्रूव करने के लिए आप विटनेस लेकर आओ, फिर उस विटनेस को वो क्रॉस एग्जामिन करेगा. So the trial will become more protracted, more long. Trial will be delayed. So in order to stop that chain, they say कि आपने जो भी सवाल पूछा उसके कैरेक्टर से रिलेटेड, उसने जो भी आंसर दिया, अगर आपको लगता है कि वो झूठ कह रहा है, फिर भी आप उसको कॉन्ट्राडिक्ट नहीं कर सकते. बट आपके पास ऑप्शन है कि इफ ही इज आंसरिंग फॉल्स, देन यू कैन ऑलवेज प्रोसिक्यूटिंग हिम फॉर गिविंग फॉल्स एविडेंस इन अ सेपरेट प्रोसीडिंग्स. Otherwise, you cannot give evidence to contradict him. If you read it again, when a witness has been asked and has answered any question which is relevant to the inquiry only insofar as it tends to shake his credit by injuring his character, no evidence shall be given to contradict him, but if he answers falsely, he may be afterwards be charged with giving false evidence. अब इसके कुछ exceptions हैं, वो देख लो. 2 exceptions are there. Exception 1, if a witness is asked whether he has been previously convicted of any crime and he denies it, evidence may be given of his previous conviction. तो एक तो ये exception है कि previous conviction के लिए अगर वो मना करता है witness और वो previously convicted हो चुका है, तो उसको कॉन्ट्राडिक्ट करने के लिए आप एविडेंस दे सकते हो. द सेकंड एक्सेप्शन है, इफ अ विटनेस इज आस्क्ड एनी क्वेश्चन टेंडिंग टू इम्पीच हिज impartiality means biased. He is not impartial, he is biased, and answers it by denying the facts suggested, he may be contradicted. अब देखो, विटनेस से आपने बोला कि तुम क्या पहले कन्विक्ट हुए हो, और वो कह देता है कि नहीं, तो आप उसके लिए एविडेंस दे सकते हो उसको प्रूव करने के लिए. और आपने कुछ उससे ऐसी बात पूछी जिससे उसकी इम्पार्शियलिटी इम्पीच हो रही हो, उससे दिखता है कि ही इज बाइस्ड, ही इज अगेंस्ट द पार्टी फॉर हुम ही इज गिविंग द एविडेंस, फॉर अगेंस्ट हुम ही इज गिविंग द एविडेंस. तो अगर वो मना कर देता है तो उसको भी कॉन्ट्राडिक्ट करने के लिए आप एविडेंस दे सकते हो. और इसके लिए देखो इलस्ट्रेशन डी. A is asked whether his family has not had a blood feud with the family of B against whom he gives evidence. मीन्स A की फैमिली में और B की फैमिली में जानी दुश्मनी है, झगड़ा है. अब A is giving evidence against B. अब the lawyer puts a question that does not your family have an enmity with the family of accused? And in answer A says no. A says no. He denies it. He may be contradicted. He may be contradicted on the ground that the question tends to impeach his impartiality. He may be contradicted on the ground that the question tends to impeach his impartiality. मतलब वो impartial नहीं है, इसके लिए आप एविडेंस दे सकते हो. देखो, अब उससे आपने सवाल क्यों पूछा? क्योंकि आप उसको पार्शियल घोषित करना चाहते हो, आप उसको बायस्ड घोषित करना चाहते हो. That is why you asked the question. And he answered that no, I am not biased. I do not have any enmity. So in order to prove the enmity, you can give evidences. Now you read the illustration number C also. A affirms that on a certain day he saw B at Lahore. A affirms that on a certain day he saw B at Lahore. तो A एविडेंस देता है कि किसी सर्टेन डे पर उसने B को लाहौर में देखा था. अब A is asked whether he himself was not on that day at Calcutta. अब इससे पूछा गया कि उस दिन क्या तुम खुद कलकत्ता में नहीं थे? A is a witness, कहता है कि मैंने B को एक डेट पर लाहौर में देखा था, एक पर्टिकुलर डे पर लाहौर में देखा था. वो शायद एलिबाई का विटनेस होगा या वॉटएवर. तो A से सवाल पूछा लॉयर ने कि तुम उस दिन खुद तो कलकत्ता में थे, तो तुमने लाहौर में B को कैसे देख लिया? Were you not at Calcutta on that day? Then in answer he denies it. Then evidence is offered to show that A was on that day at Calcutta. The evidence is admissible not as contradicting A on a fact which affects his credit, but as contradicting the alleged fact that B was seen on the day in question in Lahore. In each of these cases, the witness might, if his denial was false, be charged with giving false evidence. अब ये पोर्शन A B C इलिस्ट्रेशन तीनों के लिए बात कर रहा है. अब फिर से पढ़ो इसे. A affirms that on a certain day he saw B at Lahore. ये कहता है कि मैंने B को लाहौर में देखा on a certain day. अब लॉयर ने सवाल पूछा कि उस दिन तुम खुद ही कलकत्ता में थे. Were you not at Calcutta on that day? A is asked whether he himself was not on that day at Calcutta. He denies it. Now evidence is offered to show that A was on that day at Calcutta. अब अगर जनरल रूल से जाओ, then this evidence should not be allowed, क्योंकि ये एक्सेप्शन में तो फॉल कर नहीं रहा, because it is not for the previous conviction and it is not the case related to impartiality. So this contradiction shall not be allowed. But they are allowing it. Why? You see, the evidence is admissible not as contradicting A on a fact which affects his credit, but as contradicting the alleged fact that B was seen on the day in question in Lahore. So ये जो contradiction है वो section में allowed नहीं है. Actually B has taken the plea of alibi. He says that I was at Lahore. Now A says that I had seen him at Lahore. Means he is supporting B in his testimony to prove alibi. Now you can just prove that A himself was not in Lahore. Then the alibi is defeated because there was no evidence. तो हम ये जो प्रूव करेंगे that he was not at Lahore, he was at Calcutta, वो एक्सेप्शन की वजह से प्रूव नहीं कर रहे हैं, वो डायरेक्टली फैक्ट इन इशू से रिलेटेड है, सॉरी रेलिवेंट फैक्ट से रिलेटेड है. और रेलिवेंट फैक्ट क्या है? प्ली ऑफ एलिबाई. अब यहाँ पर उस प्ली ऑफ एलिबाई का डायरेक्ट एविडेंस क्या है कि ए ने बी को देखा वहाँ. डायरेक्ट एविडेंस इज दैट ए ने बी को देखा. तो अब अगर आप ये प्रूव कर दो कि ए खुद वहाँ था ही नहीं, तो ए ने बी को कैसे देखा? तो वहाँ पर उस एलिबाई को डिफीट करने के लिए आप ये प्रूव कर सकते हो दैट ए वाज एट कैलकाटा ऑन दैट डे. नॉट बिकॉज यू आर डूइंग सो अंडर दिस सेक्शन 153, बट सिंपली बिकॉज यू आर डिस्प्रूविंग द एलिबाई, द प्ली ऑफ एलिबाई और द एविडेंस ऑफ एलिबाई, यू आर प्रूविंग दैट ही वाज इन कैलकाटा. अब इस पर लिख लो एक सेंटेंस इलस्ट्रेशन सी पर. Here the contradiction is allowed not because it fall under one of the exceptions of section 153, rather because it directly defeats the plea of alibi. It directly defeats the plea of alibi, which is a relevant fact. Now see illustration B. A witness is asked whether he was not dismissed from a situation for dishonesty. He denies it. Evidence is offered to show that he was dismissed for dishonesty. The evidence is not admissible. इसका रीजन मैंने बता ही दिया. Evidence becomes too long, trial becomes long. That is the logic and purpose for that. Similarly, a claims against an underwriter is resisted on the ground of fraud. The claimant is asked whether in a former transaction he had not made a fraudulent claim. He denies it. Evidence is offered to show that he did make such a claim. The evidence is inadmissible. Okay, same logic, same reason as we already discussed. So that's it for this topic and this lecture also. Thank you.